Good morning. James Manson here, constitutional lawyer. I'm reaching out because it's been a couple of weeks since I've done one of these videos, and I wanted to give everybody an update about where things stand in the prorogation challenge. As everybody knows, the challenge is taking place on February 13th and 14th in Ottawa. We've learned that the hearing itself will take place in the Supreme Court of Canada building, not the big chamber where the 9 justices sit, but one of the smaller rooms that are kind of on the side. But that's obviously a very great privilege and an honor for us to be able to take this case to the Supreme Court building in Ottawa. Again, that's happening on February 13th and 14th. And just to give everybody a quick sense of where we are in this, my team and I have been working very hard for the last couple of weeks since we found out about the urgent hearing. We've had a lot of steps to deal with. Just so everybody understands a little bit about how it all works, a few days after the decision came from the federal court granting us an expedited hearing, we had to submit what we call the affidavit evidence. What that is a series of documents from our clients as witnesses, and they swear testimony in a written document. And basically that was giving essentially all of the information that from our side we feel is important for the judge to hear and understand. So we would be talking about, for example, the upcoming economic threats from President Trump, the current status of Parliament, things like that. Anyway, following the presentation of the affidavit evidence, our team then got to work drafting our legal brief, which is about a 30-page document. It's around 10,000 words. And what that document does is it sets out all of the arguments that we want to make before the judge on the 13th and 14th. So there is a number of arguments that we're going to have to make. Naturally, some of them are quite technical. Some of them deal with things like, does the federal court have jurisdiction? What that means is, can the federal court even hear the case? Another one would be, for example, do our clients have a legal right to be here at all challenging the prorogation decision from the Prime Minister? Do they have enough of an interest in the case so that the judge ought to hear their arguments at all? Those are some of the technical arguments we've got to deal with, and we've addressed all of those. Then, of course, as I've said before, the main issues in this case really are dealing with, again, the scope of a Prime Minister's power to advise the Governor General to prorogue Parliament, to shut down Parliament. And like I think I've said in previous comments, we don't know what the answer to that question is in Canada. There was a case from the UK back in 2019 where that was answered. We will be arguing that that case ought to have strong persuasive value here in Canada, that the court should take it under advisement and should do basically a similar thing. And what that means is that there are some limits on a Prime Minister's power to advise the Governor General to prorogue Parliament. That's going to be our argument. Once we figure out what those limits are, if any, then we will be arguing, of course, that the decision in this case was not up to that standard. We will say that the decision to prorogue Parliament in this case really was more for political reasons than for anything else, and that is not a proper functioning of the Constitution, essentially. Like I've said in many interviews since this all started, this is not a political case. We are not advocating for any political party or any particular outcome in Parliament. If there's a non-confidence motion or not, or anything or not, is not our client's concern. Our client's concern is all about the Constitution and making sure that the proper people are exercising the powers they have within the bounds of the law. So that is essentially what we've been doing. We've been spending a couple of weeks, 10 days, trying to get all these arguments down on paper. We're almost finished, and our materials will be due to be filed on Monday, so 2 days from now. And after that, we'll be waiting for the Crown, for the government lawyers to produce their legal brief as well. And then we will proceed to the hearing next. I guess it's in 2 weeks from now, a little bit less than 2 weeks from now. So that's really where things stand. The only other thing that's maybe interesting is that there have been a few other entities and groups that have come forward, and they have asked the court to be interveners. And what that means is that these are people who are not directly involved in the case, but they believe that they have some helpful and useful information that the court would want to hear to help the court as it makes up its mind on the issues that we've raised. So these people can't create new issues for the court, and they can't really file new evidence for the court to consider, but they can lend a helping hand to the court to give more legal submissions about a given issue, and from their point of view, what should be the right answer. Interveners are not supposed to be partisan. They're not supposed to take one side or the other in this case. They're supposed to be neutral. And so their arguments are generally pretty balanced, and they're generally designed to help the court in its task. There are a few of those people who have reached out to the court and asked for permission to be interveners, and we haven't yet gotten a decision from the court as to whether they will be granted leave to intervene or not. So we'll have to wait and see on that. The only other thing I wanted to mention was that I understand from my communications people that we have gotten some questions and some comments, and a lot of those questions and comments deal with a common issue. And that common issue is, why is this taking so long? People have understood that there's an urgent hearing that's going to happen, in a couple weeks, and they say, well, that's still too long. The country's on fire and the government is gotta go or whatever, and why is this taking so long? And I just wanted to make sure that everybody understood it's not taking long time. This is actually a very, very, very fast process. I, for one, am exhausted, and my team is also very tired. We've been working not around the clock, but not too far away from around the clock, and it does take a lot of time and energy to write down all these important and complicated arguments based on very important and heavy constitutional principles. It takes a lot of time and energy to really focus those thoughts into a coherent argument. And then, of course, as I mentioned before, we have to prepare all the evidence, which involves talking to the clients and getting a draft put together. Then they have to review it, and then we have to make changes and all these things. And all of that takes a lot of time. Running a lawsuit or a case really isn't like the movies, right? Or TV. It's not like you get a case on Monday and you're in court arguing it on Friday. That's just not how it works. These things take enormous amounts of time and energy. And that's all for the benefit of the court, because of course the judges are busy people and they've got hundreds of cases to deal with all the time. So they need our best, most focused presentation that we can give them in order to help them make the best decision. So ultimately, while it's true that in the UK, in that case from 5 years ago, the entire thing took about a month. That was extraordinary. And I think also they had some lead time. I think it was a bit of a different fact scenario over there, and they had a bit more, advance warning that the prorogation was going to take place, so they could get their ducks in a row before it even happened. We didn't know until January 6th, which was the actual day, right? So ultimately, though, I can promise everybody that this is about the fastest I've ever seen a case go. And I know that the federal court is taking it very seriously. They've given us a very prestigious courtroom in the Supreme Court building, and they've given us a very, very tight timeline to deal with. And so I appreciate that the faster we can get into court, the better it might be for everybody, particularly if the court, is with us in the end and Parliament then reopens. But please trust me when I say we're going as fast as we can, and we're doing the best job that we can. also respecting that these arguments require time and a lot of thought to get out on paper properly, right? So anyway, I hope that answers the question. And anyways, if anybody has any other questions, please, comment, and we'll see if we can get some answers going. The final thing I will say would be to please check out my organization's website. That's jccf.ca. You can find a lot of information there about this case and also other cases that we're doing across the country. Other lawyers, I think we're about 8 or 9 lawyers. As you may all know, our salaries depend on donations from the public. We don't bill anybody anything for our time and our effort. So every bit counts. I know things are difficult these days and they might be getting harder in the next couple of days and weeks, but every bit counts. And we're certainly glad to be here to do this work for everybody. So, by the way, all donations are tax deductible, of course. You get a tax receipt for that. So anyway, that said, thanks again. Thanks for listening, and I'll provide another update soon. Have a good day. Thanks.